Hey everybody, it's Andy, and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York, and in this video I'm going to go over the major thing, certainly not the only thing, but the major thing that I think a defendant in California criminal court should do to be more successful in their case, I mean. So I guess I'm going to preface this video by saying that I don't know your situation, obviously. I'm standing here talking to a camera that, to be honest with you, has way too many buttons and features and stuff on it for me to figure out. But aside from that, I really don't know your situation at all. All I know is that I'm talking to this camera. I don't know the facts of your case. I don't know your criminal history, if any, and so on. So the advice I'm about to give, the thing I'm about to say, is obviously, you have to temper it by that. You have to use your own common sense, your own judgment to determine whether or not this applies to you, how you can use it, and so on. So the second kind of disclaimer, I guess, that I have to give at the beginning is that I don't know the facts of your situation, so I certainly don't mean anything that I'm about to say as being sort of judgmental or placing blame or anything. Every person has, what's that kind of aphorism, like everybody has their own struggle and you never know what the other person's going through. So that applies also. So don't mean to kind of give you precise advice. Don't mean to criticize or be judgmental about the history that you have, for example. But yeah. So anyway, those two things aside, this is the thing that I think a lot of defendants in California criminal court don't do, and they really should. And if they did it, it would most likely benefit their situation. And I guess every criminal case is different, so I'm going to talk about just kind of the most common scenario, and that's going to be a misdemeanor case in California criminal court, specifically Superior Court in California. So the one thing that I think a defendant in a case like that, can do to increase their chances of resolving the case successfully is basically be disciplined about how you handle the case. Now, a lot of you are probably looking at me going like, well, yeah, Andy, no shit. Like, what does discipline mean? Like, what am I supposed to do? What am I supposed to not do, etc. So I'm going to give you a couple things that I think a disciplined defendant in a California misdemeanor criminal case, should do. So number one, this is going to sound really silly to say, I guess, but it does deserve to be said. Number one is that if you're a defendant, show up for court when you're supposed to. So if you are a defendant, even if you have an attorney or public defender or something, chances are you're going to need to go to court at least once. The judge in your case most likely is going to set, an arraignment date. There's going to be a pretrial date, possibly several pretrial dates. At one or some or all of those court dates, you might actually need to be physically present. It varies from case to case. But chances are, if you're a misdemeanor criminal case defendant in California, you're going to need to go to court at least once. It's not complicated, to kind of go to court when you're supposed to. If you have a calendar of any kind, smartphone, day planner, calendar on the wall, whatever, you just need to go to court. Write it down, go to court when you're supposed to. Yeah, it's not hard. So, yeah, if you don't go to court, and I gotta be honest here, before becoming an attorney and going to criminal court, I would have never guessed at how many, defendants don't go to criminal court when they're supposed to. If you don't go to court, what happens basically is that the judge will most likely issue a bench warrant for your arrest. And what a bench warrant basically does is that if you get stopped for anything, traffic light, you ran a traffic light, you didn't stop at a stop sign, you were speeding, anything like that that normally you might just get a citation for and kind of, the officer would just let you go. If you have a bench warrant, the officer generally won't. Instead of just getting a ticket, you're going to get arrested, go to jail, etc. So it's just a big, humongous mess. If you have a bench warrant, get it taken care of right away. Yeah, or better yet, just don't get a bench warrant, period. So the first thing is basically, my first tip is show up for court when you're supposed to. Now, what I said at the beginning about not being judgmental, etc., I can completely understand, I guess is the best way to put it. I can completely understand that getting to court is easier said than done, especially if you have, childcare responsibilities, if you have a job that really doesn't give you the time off, if you live really far away, you don't have a car, etc. If you know that you are dealing with situations like that, do your best to plan around them, I guess. Like the court, the court doesn't really kind of factor that in. It's like, if you have this type of case, you need to be present to do your plea, you need to be present at arraignment, etc. So, just because you live far away, you have childcare duties and stuff, that doesn't excuse you from that type of stuff. So you're gonna have to find a way to deal with it. Yeah, I think I've beaten that horse to death, I guess. So number one is show up for court when you're supposed to, so you don't get a bench warrant. Maintain a calendar, write it on the wall, have somebody remind you, do whatever you need to do to get to court when you're supposed to. That's number one. Number two is, again, probably easier said than done in some cases, but number two is don't get any new cases. If you're facing charges for case number one, while you're out on OR release, for example, own recognizance release, don't get new cases. Don't get arrested for something else. Certainly don't get arrested for the same crime again. Because if the judge sees that you are facing charge number one and yet you're facing charge number two for the same thing, essentially, the judge is going to go, hey, this guy really is a problem. He's a habitual offender. We need to punish him more severely than if he just had one case, for example. So having a second case or a third case even, generally speaking, is going to make your case more, or make any of your cases more complicated because you look like a habitual offender. That's all. So number three is kind of related to number one, actually. So if you go to court when you're supposed to, that obviously makes it a lot easier to sign forms, do anything else that the court needs you to do. I've had cases before, for example, where the defendant needs to sign forms of various kinds. The court just wants them to sign stuff. And thankfully, the defendant, my client, was always there for each of those cases. But if they weren't, then obviously signing the form is a lot more complicated. So go to court when you're supposed to, and one kind of benefit of that is that you can sign documents when the court needs you to sign documents. Number four is what I'm up to now. I guess, again, this probably sounds really basic to say. If you have an attorney of your own, or if you have a public defender even, keep in contact with your attorney. Return his calls or her calls. If your attorney emails you, email them back. If your attorney sends you something, via snail mail, send it back. Sign it, send it back. Keep the avenues of communication between you and your attorney open. I've also had cases myself, and I've also seen a lot of other lawyers, public defenders as well, go to court and basically tell the judge, Your Honor, I'm sorry, my client's not here. I've lost contact with my client, and so on. So that type of situation unfortunately does happen. The client, for example, could be in a coma, in a hospital, whatever. But a lot of times I kind of also get the impression that clients just basically don't, or defendants rather, don't keep in contact with their attorney. They don't respond to emails, they change their phone numbers without telling the attorney, etc. Keeping in contact with your attorney generally is going to make your case easier to resolve, resolve it faster and so on. So I think that's number four. Number five and number six are kind of related, so I'll go over them both at the same time. If you are, depending on your case, of course, you possibly might have a regiment of things that you have to do. So, for example, you might have a DUI class that you have to go to, twice a week for 3 months or something. Or you might have a fine that you have to pay, say, $200 a month on for a year or something. If you have an obligation to do something over time, go to a class, pay a fine, something, whatever, do that. Do what you're supposed to each month. So the thing is, pay your fine, go to your class, do whatever it is you have to do. Check in with your probation officer, when you're supposed to, and so on. If you do all of those things, generally speaking, your case is going to, hopefully go easier for you. If you don't do those things, your case is going to be more complicated, worse and stuff for you. So I tried this analogy with, in person with some other people, and it seemed to work. So I'm going to try it here, and if it doesn't work, forgive me, but hopefully this point gets across. If you imagine the movie Forrest Gump, so the movie, hopefully you all have seen it. I want to say it's from 1994. Tom Hanks played Forrest Gump, won Best Picture, etc. So Forrest Gump, if you haven't seen the movie, basically seems to fall into a series of fortunate, kind of happenstances, I guess. And if I remember the movie right, he, demonstrates kind of ability for football. He goes to college on a football scholarship, joins the army, goes to Vietnam, gets injured, gets the Medal of Honor, becomes a ping pong champion, invents the sushi burrito, etc., etc. So the Army portion is going to be the relevant scene here. So hopefully you guys can find it on YouTube or find it via the DVD, if you happen to have it. There's the scene where Forrest Gump, Tom Hanks, basically goes to boot camp, and everybody around him is struggling, with boot camp. But Forrest basically says this, the Army's not that hard. You got to stand up straight. You got to make your bed, when you're supposed to, and you got to do what you're told. And above all else, you got to say yes, drill sergeant, at the end of everything. So the point there is that if you're in the military and you follow orders and you do what you're told, the process is actually not that difficult. So in criminal court, I would say that the same kind of idea applies. If you are supposed to go to a class twice a week for 3 months, you do that. If you're supposed to pay a fine, you do that. If you're supposed to show up for court on January 15th at 1 p.m., you do that, and so on. So if you do those things, again, individually, it's not that hard, but it does require some level of discipline, organization, and so on. If you do those things, generally speaking, at least in my experience, your case will go easier. If you don't do those things, your case will be more complicated. So hopefully all of that kind of makes sense. Hopefully the Forrest Gump analogy worked. Let me try to explain why being disciplined is beneficial. So I don't think it should be a surprise to anybody. Hopefully nobody in the court system is surprised by this. The courts, regardless of where you live, California, some other state, etc., whatever, the court system, the probation system, police officers, deputy sheriffs, whatever, there's only so much budget. Each of those entities only has so much budget, so much bandwidth, so much manpower, and so on. If you do what you're told, when you're told to actually do it, you're less likely to warrant attention, and especially negative attention is what I'm referring to. So think of it like this. If you do what you're supposed to, you follow the rules, you behave, in the grand scheme of things, you are a small fish. So you're a small fish over here. If there's limited budget, finite resources and stuff, the court is not going to spend a lot of resources worrying about these small fish, for example. Probation is not going to spend a lot of time worrying about these small fish, for example. What they are going to do, what the court and probation are going to do, for instance, is they're going to spend their limited energy worrying about these big fish over here who are purposely refusing to follow the rules, for instance, who don't go to court when they're supposed to, who commit new crimes and get arrested again, second time, third time, fourth time, etc., for the same offense. They're the ones who don't go to class when they're supposed to, don't pay their fine when they're supposed to, and so on. Those are the big fish over here, and those are the ones that, given finite resources, those are the ones that are going to warrant the attention, not the small fish over here. So, yeah, I guess, if you don't warrant the attention, obviously, you're more likely to resolve your case successfully, you're more likely to be able to put your case behind you, and so on. So just finite resources, the numbers work in your favor if you comply with the rules, you follow the rules, and yeah. So basically, if you are disciplined, you consistently follow through, you do what you're supposed to, you don't warrant the attention of the courts, probation, law enforcement, and so on, and you're more likely to resolve your case successfully and go on and be kind of free of any kind of law enforcement interaction. So hopefully all that helped. Go ahead and share, comment, like, subscribe, all that stuff, and I will talk to you guys next time. All right, thanks, bye.